Welcome back. You're still watching and listening to the Key Points. We're live on TV3, also live on 3FM 92.7, online at 3news.com, and on Facebook at TV3 Ghana. So we're currently having a conversation here with lawyer Yao Pong, particularly looking at the referral of Dr. Dominic Ayine by the Chief Justice through the Disciplinary Committee of the General Legal Counsel over alleged comments made questioning the independence of the judiciary, and this has to do with the just ended election petition of 2021 filed by the flag bearer of the NDC, John Dramani Mahama. In fact, the referral letter describes the comments made by Dr. Ayine as disparaging, and that is to be investigated by the disciplinary committee. So, Ms. Opon, let's look at this. I talked about the reasons that he had given, talking about the fact that there was a lack of, or the court failed to give reasons for the dismissal and refusal of applications. And does that in any way justify, the conclusion he came to?
I think that point can be made, that in your view, you expected judges to give reasons. But in this case, in all instances, reasons were given. In fact, all the applications that were brought, it is sometimes forgotten that our own application for the case to end at the earliest possible time, because we thought that there was no reasonable course of action, was not granted. And that was a major
it was postponed to be determined together with the entire.
And when it was determined together with the judgment, it was rejected flatly.
Obviously, I saw that coming, because if it was going to be upheld, it would have been done earlier rather than.
And for us, we thought that was more fundamental than any other application, because we strongly believed that there was no reasonable course of action. It was rejected. So it is not as if every application of theirs was rejected, and as if ours, that is speaking for the second respondent, was granted. That was not the case. Our application, which was, well, we had one major fundamental application, was rejected. And in the course of the hearing, objections were raised by us, which were not upheld. They are also a form of questions that had been put, even though there was no formal application. A lot of times, if I got to a time our lead counsel also thought that he was not being extended the same kind of magnanimity that was extended lead counsel for the petitioner. I mean, that was a genuine concern that some of us also felt. But that is the nature of it. So no impression should be created to make it seem as if one person was done in and the other side benefited unduly from the decisions that the court gave throughout the proceedings. No, it is not the case at all. And I'm saying that in all cases, reasons were given. These decisions, and we all have them, fortunately, a lot of them were online. You can go back and check. There were very extensive discussions in them, and sometimes you wonder how in a day or two they were able to nitpick various points that were made, got the authorities for them, and ruled on these points that were raised in the course of the proceedings. So even if a judge gives a decision without reasoning, it can never be a foundation for any claim that then that judge has no mind of his own or is not independent. It can never be, in my view. And that is why I'm saying that Dr. Ayine himself needs to have a reflection over this, and I believe he would have.
Very well. Now let's look at this as well. The rules for the conduct of a presidential election petition were revised.
That's right.
To avoid what we saw in the previous election petition of, was it 2013? Where it took forever, 8 months. I mean, the discussions over that prolonged hearing, I mean, we all know about that, which obviously led to the revisions. And so clearly for this one, we set out knowing that we were time bound.
That's right.
Do you think that may have affected how people perceived the proceedings? Because there's been instances where people have had cause to complain, or people have complained about the CMC that was held, that the rules allowed for a certain time frame, but it was done shorter than the time frame allowed. It looked as if, yes, we were trying to meet that, was it the 42 days within which to complete the process from the time the petition is filed and all of that. Do you think, in as much as that revision was made to serve a certain purpose, perhaps it brought about some sense of, let's hurry up to do something, so people may come then to say, we were rushed through the process and all of that. Is there any weight to that kind of argument?
Well, I, by my nature, I don't usually say that anybody is wrong on this point. On the law, I'm saying that I disagree completely. I mean, it doesn't matter the length of time given you. I mean, currently, there are some judges that hold a view that because of CI 87 and how now you file your witness statement, attach all your exhibit and so on, the idea that cross-examination is the sky is the limit, no more holds. And they will pin you down. I did said one day you have to finish. 30 minutes, 1 hour, you have to finish. And you have to finish. Because the judge who is making the determination has had the benefit of both the pleadings with witness statements and possibly would have made up his mind and just waiting to see some clarifications that will be made this way or that way. So in this particular circumstance, and I'm saying that in spite of the quote-unquote limited time, and again, it is not exactly, I disagree if somebody says that anyone was rushed through. The point is that within that period, opportunities were offered. I mean, you have no idea when you have prepared for the next day, and then midnight, an application is filed, and you need to prepare for that one and the previous one, and as the ruling is being given, there's a review that is filed. You can't go home, you have to go and sit on it. So all of us would have wished that there was more sufficient time to deal with it. But that is what the law now says, and I think it did not hinder a fair treatment or fair opportunity that was given, or that the case itself demanded. It was fairly contested. The whole world saw it. In the court, sometimes you go there 9 o'clock and leave there after 5 p.m. The strain on us was telling, and all the judges themselves. So it's not as if that they would have wished, it's not as if they didn't want perhaps more time, but the law had bound us. And for the case management issue, when you put the days together, it was more than that, because remember, amendments were made on the other side, from the other side, responses were made by us. And when you put all those days together, the time for CMC was exceeded. You understand? And the bottom line really is that this matter was fought fairly and squarely. Both lawyers, all lawyers in it did exceptionally well. The judges were on top of their case on all the applications that were brought. And because we know that the Supreme Court is not only a policy court, but the Supreme Court, quote unquote, makes laws for the rest of us, and especially the courts below. And so it is very important that the time given them would have been longer, but within the short period, inordinately short period, prescribed by law, they were able to discharge their duties, for me, perfectly. And so whatever it is, your disagreement or dissatisfaction, in my view, cannot lead you to say that because of that, they don't have a mind of their own, or they are not independent.
Now, another sticking point in this election petition obviously had to do with the EC's, the EC chairperson not mounting the box to, give evidence, and that has been described as the Supreme Court shielding the commission from, rendering an account, as it were, to the people. And indeed, Dr. Ayine talks about the accountability aspects of it. He mentions it here in laying the foundation for his eventual opinion, which he stated, questioning the independence of the judiciary and that they didn't have a mind of their own. Let's talk about that a bit.
Well, I mean, I still believe that anybody can make their points known on these matters. But in terms of this whole proceedings, it will be just unfair to impugn the integrity of the judges. Because when matters came up, opportunities were given. I mean, sometimes 1 hour to a lawyer to argue his case out cannot be said to be inordinately insufficient. And when all these opportunities have been given and the case has been fought from the beginning to the end, we saw how they extended some unfamiliar magnanimity to the parties and their lawyers. I mean, sometimes you ask yourself, even a district court, no, I don't mean to demean them, but a district court judge would not entertain lawyers in their court the way the Supreme Court in the election petition case, because of the special nature of it, extended this unprecedented, to use the word, magnanimity and entertainment of matters that in ordinary cases you will not get that. And so we need to look at all that in totality and come to the conclusion that whatever happened during that period, they were within the law, the facts were supported. The final judgment, I mean, is one of the best judgments that I have read. And the authorities have clearly been on point. And when people express their view on these matters, that is fine. Coming to the accountability of the Electoral Commission, the fact that the Electoral Commission was sued itself is a call to accountability. It is basic, even with all due respect, in the Chief's Palace. It is said that you cannot compel a person to drink the water when, after you had even compelled that person, and this time using person for a horse, as we put it, to the river. It is even unfair to compel a person to give evidence against himself, to implicate himself, and so on. You have brought him to court, and it is for you to establish your case first on the pleadings, that's the facts that you present, and 2, on the evidence, before the other person is called to answer. I mean, this is very basic. And if he says that, and it is done before the Chief's Palace tribunals.
But you stated, I mean, in all the discourse over election petitions, at the heart of it is the recognition that the presidential election petitions take a certain space.
That's right.
So the argument that we should treat election petitions or presidential election petitions as quote-unquote special, some would say perhaps there's some truth in that. And so if we're treating it special, then you're talking about the unfamiliar magnanimity that is extended to. Of course, I mean, watching the proceeding, you're like, whoa, if only you would have days like this in the Supreme Court. Because you don't get it like that.
Yeah.
So then there's that, quote-unquote admission that, yes, then there's some special place we give that. So then perhaps you could also then.
Yes, but you should remember
Do some things about.
You should remember also that that special, quote unquote, special nature of the case must be within the law itself and the established principles and practice. Can you really, in treating a matter before you as a judge as special, violate the common principle that you cannot compel a person to give evidence against himself? For example, you can compel him to appear before you, but it is for that person to decide whether or not you give evidence. And when the person has filed his evidence, and that evidence is yet to be received or adopted by the court, is it really fair to violate the law by compelling that person to give evidence? The law says that even after the person has filed his witness statement, that person in law can elect not to ask the court to adopt that evidence. And when that is done, I think that you cannot say that because of the special nature of this case, and in spite of the fact that the law is clear and unambiguous, we will in a way violate it in order that the special nature of the case can be realized.
Very well.
Knowing that judges, like the rest of us, are also bound by the law.
Very well.
And when you are giving such concession to other person, you must think about the person against whom that concession may be applied.
Very well.
And it's important that the rights of, for example, it wasn't only the EC. President Kufuor also said he won't give evidence. So would it have been right to compel the EC in the circumstance to give evidence, but the second respondent, you'll be okay with it if the second respondent was not compelled to give evidence?
Very well. Laura, let me cut in there and cross